we have got an episode that's sure to pique your interest and keep you on the edge of your seats. So fasten your seatbelts, folks, and get ready for a riveting conversation that's sure to leave you enlightened, empowered, and maybe just a little bit dizzy. Want to know why I use these heavy words? Stay tuned because you'll get to know soon. Hello, everyone, and welcome back to Immigration and Jobs Talk Show, where we dive deep into the ever evolving landscape of immigration policies and their impact on job opportunities. I'm your host, Rajni Bharara, and today we are tackling some hot button issues that have been making waves in the immigration world: the USCIS fee increase, changes to the lottery, and the rollout of the new H-1B regulations. These developments have been causing quite a stir, with implications for both employers and individuals navigating the complex maze of immigration procedures. To help us unpack and understand these changes, we are honored to have with us Jonathan Wasden, an esteemed expert in immigration law and policy. Jonathan brings us a wealth of knowledge and experience to the table, making him the perfect guide as we navigate through the intricacies of these recent developments. So, buckle up and get ready for an enlightening discussion as we delve into the USCIS fee hikes, the revamped lottery system, and the implications of the new H-1B regulations. Without any further ado, let's give a warm welcome to Jonathan Wasden, everyone. Hi, John. Welcome to the show.
Thank you. It's good to be with you.
Great. Thank you so much. It's a pleasure having you on the show always. I mean, we only had our first episode with you, I think, a week or two back. And this is our second episode with you. So it's an honor having you on our show.
Well, thank you for having me.
Lovely. All right. So, to our lovely audiences out there, I would like to say that please note that this session is being streamed live on YouTube, LinkedIn, and Facebook. And the handle is Immigration Talk Show. Don't forget to subscribe to us. And if you have any questions to Jonathan, wherever you're watching it from, please comment with your question. We'll be glad to answer them. All right, let's get started and let's dive right into the topic and take up our very first question. So the first question, because the episode is all about USCIS's fee increase, so we are going to talk about that first. So John, can you please explain the recent USCIS fee increase and its impact on immigration and businesses?
Yeah, sure. So last January in 2023, they published their proposed rule of what they wanted to do to change fees.
Mm-hmm.
That just went final about 2 weeks ago. So it is final, and then there's a 60-day grace period until it goes into effect. So on April 1st, it'll go into effect.
Okay.
The fee increase is really part one of USCIS's two-step process to try and eliminate as many staffing companies from the H-1B process as possible.
Mm-hmm.
And so they're doing that by increasing the number of the amount of fees you've got to pay, as well as the second regulation that will be coming out will be really limiting people. So to give you an idea about the fees, for companies to file an H-1B, your fees are going to go up, close to 50%. And so if you look at the standard contract length for the industry, is 6 months for an H-1B worker at a staffing company, you'll be paying that fee every twice a year, and it can get cost prohibitive.
Okay. So, whenever the fee increase happens or whenever any changes happen, so we always talk about what's the impact that's going to, happen after the changes. So let's talk about the impact now. So if you can please explain how will these fee increases affect the overall immigration process?
So the fee increases, when they're coupled with the new H-1B regulation, are going to mean that your petitions are a whole lot more difficult to prepare, file.
Mm-hmm.
So the amount of time lawyers are going to spend on each one is going to increase, and collateral effect is, attorney fees will probably go up. So the overall impact, my guess would be, in the short run, they're probably going to not see a huge difference. But as those costs start racking up with especially smaller companies, I think you'll see a dramatic decrease in the demand for H-1B workers just because it gets too expensive to do.
Mm-hmm. Okay.
The downside to that is that we don't have people to replace them. And so USCIS is, pursuing this policy to eliminate staffing companies without really comprehending the value staffing companies have.
Mm-hmm.
Because they're working on these short contracts, if they, aren't allowed, those short contracts are done for, either emergency or temporary jobs, which nobody wants to hire a full-time employee to do because it's a short project. Those short-term projects will not be getting done as effectively, or they'll be getting done from them.
Okay, but for the ones who don't know about the fee, can you tell them that how much percentage can we expect?
So if you're working for a company that's under 25, percentages are going to go up 53.8%. If you're working for a company larger than 25, it'll go up 30%, 37%. So it's a pretty good increase.
Yeah. But then, why is the increase so much with so much of percentage? Why do you, why do you think it is so much?
So not only did they increase the price for the I-129 substantially, they also created a new fee, which is very interesting. It's the asylum fee that only companies have to pay. And if you're, again, less than 25, you pay $300. If you're more than 25, you pay $600. And so that is a big chunk of this fee increase.
Okay, got it. But then, let's talk about how these, you already have told that how these fee increase is going to affect the overall immigration process. But are there any exceptions or waivers available for certain applicants?
So for the asylum fee, if you're a nonprofit corporation, you don't have to pay it. But other than that, there's really no other waivers for fees.
Okay. Short and simple then. Okay. Yeah. Thank you so much for answering the question. And everyone who's watching us right now from different platforms, LinkedIn, YouTube, Facebook, make sure that you have your questions ready because we have an expert with us today. Not just any expert, but a very famous expert. So he's going to give you answers to your questions. So make sure that you have your questions framed properly, all your doubts and whatever that you need clarification on, just have them framed properly and you can drop them on the comments on LinkedIn, Facebook, and YouTube. Now, John, coming to my next question, because we are discussing about H-1B lottery also. So we have already, I'm getting from a team that we have already started getting some chats and some questions from the viewers already. We are just 9 minutes into the show. So people are really excited to see you and they are really excited to know answers from you. All right, so now let's talk about the H-1B lottery system. So could you please discuss the changes that has been made into the H-1B lottery system and the rationale behind them?
Yeah, so the lottery process is evolving slowly. Gone are the days where you used to have to send in your petitions prior to running the lottery.
Yeah.
They replaced that with a system that everybody predicted would fail. And that is, they replaced it with a system where it was an employee was selected by lottery, but 30 people could put in for that employee in the lottery. What they're doing, because that lent itself to abuse in the agency's eyes, what they're doing now is you can have as many employers register for you as you want, but you're only going to get one bite at the apple. You're only going to get one minute in the lottery.
Okay. Okay, so as I can see on the right hand side of my screen, I am getting chats from, I just would like to take names, if you don't mind, of our viewers who have posted their questions. Sam Dilton is there, and then Krishna KRK, and then we have Sai, Minal Thakur, Harsha, and so many people, Majid. So they have posted their questions on questions for you. We are definitely going to take them, but in a while. So thank you for answering the question about the H-1B lottery system and the rationale behind them, about the changes, rationale behind them. So let's talk about the motivation behind it, basically. So whenever the changes happen, there is some motivation behind making those changes. So could you discuss what was the primary motivation for altering the H-1B lottery process?
Yeah, so as with most things that USCIS does, the primary interest was protecting the large tech companies and
Oh.
their access to H-1Bs. And so to do that, they went to this much more expensive lottery,
Mhm.
and they're focusing just on the employee and not the employer, because smaller companies in the agency's eyes were more flexible and could collude together to increase the odds of selection. They came up with a system that honestly is probably more fair to the
Mhm.
individual worker and gives everybody the same shot once they're entered into the lottery.
Okay. Okay. But you said that it was primarily for saving the tech-driven companies, right?
Yeah,
So why did you say that? I mean, what's it to
because
protect basically?
yeah, if you have a handful of small tech companies
Hmm.
all applying to the same person, like IT staffing companies all applying for the same person, working and sharing lists,
Hmm.
that person's application under the old system had a much higher chance of getting selected. Whereas if you're only entered in once by a big tech company like Apple, say, you
Hmm.
know, you your chances of getting approved or getting selected greatly diminish.
Oh, okay. Okay. And John, I was just going over your LinkedIn profile, and there you have posted that until 2017, you have worked with USCIS. So if you don't mind asking me your experience, how was your experience working with USCIS? If you can please share.
So I actually started out with the Justice Department in what's called the Office of Immigration Litigation, and that's the lawyers that go to court and defend USCIS
Mhm.
basically. And then I went in-house to work for USCIS at the Administrative Appeals Office and did H-1B and I-140 cases.
Mhm.
The number one thing I came away with from my time in the agency is they completely do not understand the sector of the economy they're impacting with regulations,
Mhm.
and they have a tendency towards animus or dislike of the Indian IT companies. And so all of their policies that you look over the last 20 years, all of their policies have been targeting
Mhm.
those staffing companies. And they're trying to do everything they can to eliminate them from the H-1B process.
Oh, okay. Okay. So, but is there a secret or something that people should know about USCIS that people want to know, but that USCIS has kept it as a secret that you would like to reveal here? I mean, nothing controversial.
Yeah, no, I think the thing that really doesn't surprise anybody, but there's a lot of people at the top of that agency that really don't like the Indian IT companies.
Oh,
And so that's driving a lot of the policy.
but what's the reason behind it?
Again, they don't understand the economy. They don't understand the tech industry structure, and they don't
Oh.
understand the role that staffing plays in it. In their view, the only people getting H-1B should be the direct employer on a full-time job, but that's just not reality. That's not how things work. So it, they're going to end up losing a lot of workers that'll be
Mm-hmm.
working only from overseas, and we won't be getting their tax revenue. We won't get their economic impact. So it's just a very short-sighted approach that they're taking.
Mm-hmm.
And if they had people that actually understood the market, they would come up with better policies. But, career government employees, they never leave. So they don't really get any exposure to what the real world is like.
Yeah. Okay. Thank you so much for answering the question, John. And now I would like to take up my next question. I mean, you already have answered about the changes of the H-1B lottery process, but now I would like to know that how these changes are going to impact the chances of foreign workers and their employers.
So for the lottery process, I think it becomes more fair. Everybody's got one shot at the lottery that they get put in, regardless of how many employers. So I think that's probably a good move. It's what was recommended, and when they created the prior lottery rule, everybody foresaw this to be a problem. USCIS said, no, it's okay. We'll just make them attest that they will file a petition if they get selected. And that was their entire approach to dealing with multiple registrations. Well, that failed miserably, and now we have this rule which addresses that problem.
Okay. And after the lottery process, I also would like to talk to you about the H-1B regulations. So if you can please explain to the audiences about what are the key provisions of the new H-1B regulations and how do they differ from the previous rules?
So there's a couple of new requirements that are in there. One is the way they're doing specialty occupation adjudications. So specialty occupation used to be a relatively simple test where you could prove you meet one of the 4 different criteria and you're eligible. So what USCIS is doing is they're saying, okay, well, just proving one is necessary, but it's not sufficient to get your visa approved. We will look at everything, the totality of the circumstances, and decide whether or not that's an H-1B job. So that they're giving themselves a lot of flexibility to try and deny cases on specious grounds. And so that remains to be seen how successful they'll be in that attempt.
Okay. And let's talk about, after you explained the H-1B regulations, now let's talk about how they are going to affect the H-1B visa holders. So can you please explain how these regulations are expected to affect the H-1B visa holders and their employers?
So the cost of, employing somebody and moving them around especially is going to get really expensive. And if you move somebody once a year, or you're paying that fee twice a year, that gets to be a lot of money. And so I think that's the initial impact. Now, how long it'll take employers to decide we don't need workers in the U.S., we need them, they're cheaper in India. That is definitely a possibility that could happen as the collateral consequence of their rules. In terms of the new H-1B regulation, the main changes that they made to that were based and targeted on Indian IT staffing companies. And they came up with a whole list of requirements that make it almost impossible for those companies to satisfy. And so that's where that fight will be, is on those changes. The bona fide job offer requirement and things like that, proof of projects and contracts. There will be probably a lot of fight on that.
Okay. So thank you so much for answering the question, John. And after that, you have answered it. We have a disclaimer here on the screen. I would like to read it out for our audiences. Everyone, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right. After the important disclaimer, John, I would like to come back to you. Whenever anything new happens, so people always think about any controversies. If any controversy is related to that, people because love to hear about controversies and conjectures, right? So now my next question to you is: are there any potential legal concerns or controversies surrounding these new regulations?
Yeah. So the government's attempt to create a bona fide job offer rule is trying to resurrect a policy that the courts told them was illegal years ago. And so they're trying to take another bite at it, rebranding it, putting makeup on the pig to try and make it look pretty, but it's the same pig.
Mm-hmm.
So the reason why it's a problem, the reason why they lost in court before, is because you can't demand that people have projects to do for the entirety of the visa. You just have to make an offer of employment. And what happens in that employment, as long as it's a specialty occupation, it doesn't really matter. So the statute actually allows people to be in what's called a non-productive status for lack of work. And that's the document created by Congress. That's the absolute controlling word on all immigration.
Mm-hmm.
So where the agency lost is when the court said, you're demanding proof of a project for the duration of the visa, but the statute says that you can be in a non-productive status for lack of work. Those two don't match, so your policy is out. So anything that contradicts with the statute is a sure loser for the government.
Okay. All right. Okay. So now let's talk a little bit about the US job market as well, because, these new rules and regulations and changes are definitely going to impact the US job market as well. So what are the potential benefits and drawbacks these changes are going to have for the US job markets, if you can please explain?
So the benefits for the lottery are that it makes everything a little bit more fair.
Mm-hmm.
The drawbacks, I don't really see a whole lot of good coming out of either the fee rule increase or the future H-1B regulation overhaul. The fee increase obviously is going to make it very difficult for smaller companies to operate. And the selection process for the lottery probably favors larger tech companies, or at least doesn't put them at a disadvantage. But I think more than likely is they start making all these impediments to specialty occupation determinations and the bona fide job offer requirement for the IT staffing companies. You're going to see a lot of people not getting approved, and you're going to see a lot of things that are revoked. And it's going to be a real mess for a couple of years until the thing works its way through the court system.
Okay. But John, I would like to know from you, in your professional opinion, because you are the expert here, and who better to get an answer for this question than you. So, in your professional opinion, if I can know from you, how can the immigration system strike a balance between protecting American workers and welcoming foreign talents?
Yeah, so obviously we are producing computer science graduates.
Right.
We're just not producing them in the right numbers.
Mm-hmm.
We have people getting degrees in Western art studies or something like that, that have no employment future or prospect of employment. And so if we want to have a successful economy, we need those overseas. Both the Republicans and the Democrats are laboring under two different delusions. The Republicans think that if you just keep out the Indians from the IT industry, all of a sudden a lot more Americans working in those jobs, but they're not qualified for those jobs, so that they won't be. There's a reason why we created the H-1B. The Democrats are trying to keep out as many H-1Bs as possible because they think the tech industry will unionize and organize, so they'll have labor unions if there aren't any foreign workers to compete. Again, the tech industry will never unionize. It will never, organize into labor unions. It's just absurd. But that's the two different unrealities that the parties are working with right now.
Okay. All right. So, by listening to you, it feels like, you're talking about these rules and regulation in such a simple way. It feels like as if someone is placing a pizza order. It's sounding so simple, but it's not that simple. It's more complicated than that. But listening to you, it is sounding like that. So, everyone, I hope so far the session is informative and helpful to you. If you need any help, don't forget to reach out to Jonathan Waston at 703-216-8148. I would repeat the number, 703-216-8148. You can also email him at john@waston.law. And you could also visit his website, which is waston.law. All right. And also, if you're looking for project placement or visa sponsorship, you can reach out to me on my email, which is rajni@higherightpeople.com. My contact number is +17327079151. You could also visit our website, which is www.higherightpeople.com. Remember, we also sponsor H-1B visas and green cards. And now let's come back to John. Let's come back to you and talk about the next question that I have for you. In terms of enforcement, if we talk about, so how does the USCIS plan to ensure compliance with new fee structure and regulations? And also, what measures and penalties can USCIS employ to enforce these changes, basically?
Yeah, so for the fee increase, they'll enforce that by not adjudicating your petition if you don't have the right fees. That one's a pretty easy solution for them. For the upcoming H-1B overhaul reg, I expect to see a pretty substantial uptick in RFEs and denials and revocations as a result of the new rules that are coming through. So I think it will be a net negative for everybody.
Oh, okay. All right. If it's going to be that, let's take up the next question. The next question that I have for you is, if you can please, if there are any recent cases or examples that you would like to share with us where enforcement actions have been taken against violators.
Yeah, so the sad reality of the fact is, although the employer is the petitioner and the employer is the only one that communicates, with the agency about the job, they don't really have any enforcement power over the employer at USCIS. The Department of Labor does, but USCIS really has no impact there. So all of USCIS's enforcement activity is really aimed at penalizing and eliminating the worker who's never done anything wrong in this process, but they're really trying to hurt their employer. They've created a team of people within USCIS that do nothing but look at cap H-1Bs right before you adjust status, looking for a way to eliminate them, and deny their I-140 or revoke their cap, so they have to leave. So there is a lot going on in terms of their enforcement strategy that is going to be problematic in the future.
Okay. All right. Would you like to elaborate on it a bit?
So specialty occupations will be difficult to define. If the rules is currently drafted in the proposed rule, your specialty occupation is going to be in the eye of the beholder of the adjudicator. Whatever the adjudicator thinks is the totality of the circumstances is what they'll be basing it on, which means there's no really bright rules that are clear for everybody to follow and create predictability. So I expect to see a lot of unpredictability with specialty occupation issues. The other main thrust of the H-1B reg is changing the bona fide, requiring a bona fide job offer in order to get an H-1B. What that bona fide job offer means is a good question. So if you look at the way the statute and the regulations are created, the employer makes an offer, they file the LCA, the petition gets approved, and they have a legal liability to pay regardless of how much you've got to do. And if you don't pay, you can go to the Department of Labor and you can get back wages, and they're pretty effective that way. So, what USCIS is doing is when they find evidence in a site visit that wages haven't been fully paid. The worst example I've seen is somebody whose LCA was for 120 a year, and their W-2 was 1,000 or 119,000. So it's off by 1,000. Could have been a lot of legitimate reasons for that. They still revoked the visa. So they revoked his H-1B visa because the employer's actions. It completely negates the right that employees have to the Department of Labor, because if they go to the Department of Labor, they run the risk of USCIS revoking their petition. So the system would work better if USCIS would work with people and look to protect employees, but they're not looking to protect employees. They're looking to get them out.
Well, that's sad, but that's the reality. And you have worked with USCIS yourself. So, I mean, who can tell about them better than you? All right. So I do have many follow-up questions regarding, what you have shared with us. But because we don't have that much time, we have got too many questions from the viewers here present on LinkedIn, Facebook, and YouTube. So too many questions here, which I need to ask from you. So I'll have to give it a rest to my questions. And now go directly into a break, because break is important. So if anyone is feeling thirsty or want to drink coffee or heat up their tea, so they can go ahead and do that. We'll be back after a short break. You guys stay tuned, because next I'm going to take up your question, viewers. So stay tuned.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back, everyone. You're watching Immigration and Jobs Talk Show. I'm your host, Rajni Varara, and today I have with me none other than the expert, the legal maestro, John Vaston. So, John, welcome to the show once again, and our audiences are eagerly waiting for you. And if you don't mind, I would like to now next take up their questions for you.
All right.
Great. All right. So Sam is here, and Sam has posted this on YouTube. And I would like to also tell you, John, that I always, say where they have posted this question, because so that people should be aware that we are streamed live on 3 different platforms, so that in case one of the platform is not working, they can switch on to the other platform. All right. So Sam is saying, "Hello, team. Very informative sessions. Thank you. Thank you so much, Sam. That's why we are doing the show, to keep you informed and to keep you updated with all the information that you need." All right. So next question. Okay, Krishna KRK has posted this on LinkedIn, and Krishna says, "How does these new regulations impact the people looking for H-1B renewal?" What do you have to say?
So the State Department has created the new in-country stamping, which I think is going to be a huge benefit to anybody that's renewing their visa or extending their visa. It takes away some of the unpredictability that's going on at the consulates right now, with people getting stuck outside of the country on 221G. So they're getting stuck outside of the country on 220G because the State Department is typically demanding evidence of a project before they will issue the visa. And oftentimes, it doesn't matter how solid your evidence of a project is, they're still not moving the employee out of 221G admin processing. So that is a real mess that hopefully the in-country stamping will address and alleviate a little bit. And then in terms of new employees coming into the U.S., I think we can, or extension employees, sorry, that are already in the U.S., I think we will see petitions that have been approved for years and years and years, multiple times, probably getting RFEs, probably getting denied, probably getting revoked.
Okay. So, Krishna, I hope you've got the answer for your question. Thank you so much for posting your question. And because we have really less time, so we are going to take up questions one by one real soon. So, next we have Sai Nityamani Matsa. So, hi, Sai. I hope you're doing good. And Sai has posted this on on LinkedIn, and he says, how many visa USCIS may issue this time based on previous year's data? Good question.
So the number of visas is fixed. That's not going to change. There's 85,000 a year in the H-1B process. For employment-based immigrant visas, that's an unknowable. There is a fixed amount of visas available, and then there's the per country limit. So if family visas don't get used, then they transfer over to employment-based. And they don't really tell you how many people are in that boat, in addition to the standard maximums. So it's really hard to know exactly.
Okay. All right. So, Sai, as John said, right now it's hard to know, but you just keep subscribing and keep watching this space so that we can let you know more about these details in depth in coming videos and coming shows. And right now, John, as you can see, people are mostly asking about these new rules and regulations. So now, coming back to my questions, I definitely am, please await, audiences, I'm definitely going to take up your questions, but because people are really curious to know about these new rules and these changes and regulations. So could you please tell us what should immigrants and businesses be aware of regarding compliance with these new rules?
Yeah, I mean, no big secret, USCIS is not your friend. If you're a worker and USCIS comes to do a site visit, you need to be very cautious in what you say. So employers, likewise, they're just going to end up having to have better and better lawyers to spend more time on each petition, and that'll get expensive.
Well, okay, but you said USCIS is CIS is not your friend. That hurts, but we'll have to move on. Okay, so let's take up our next question. The next question that we have is about if you can please elaborate on the role of US courts in addressing challenges related to USCIS fee increase and immigration regulations.
Yeah, so there's the U.S. Constitution at the top of the legal pyramid. And then the next level down is a statute created by Congress. The statute created by Congress is going to control what the agency does. Now, if there's any ambiguity in that, the government can create a regulation to kind of fill in the gap. Mm-hmm. But if the regulations contradict the statute, it's a loser. So that's one way you can look to invalidate a reg. The other one is if there's some essential factor aspect of the issue that they ignored, that's another reason to challenge. Mm-hmm. So with the fee rule, one of the interesting things is they're allowed to collect fees to recover the cost of operations. And they haven't really explained how, they need the extra money. And so I think that's going to be a problem for them.
Okay. But if we talk about federal courts, so how have the federal courts responded to legal challenges against, USCIS fee increases?
So in the past, they've blocked them. So the one in 2020 got blocked and has been, pending while this new reg comes out. Mm-hmm. So I think when it comes to the fee increases, courts are not unreceptive. I think they're probably, pretty receptive to the arguments that we'll be raising.
Okay. Okay. All right. So I think now it's time that we take up our viewers' questions once again. So after Sai, I would like to take the next viewer that we have here is Meenal Thakur, and Meenal has posted this on YouTube. And Meenal says, "I am an international student. Do I have to use practical training (F1) or academic training (J1) before I can get the H-1B?"
You have to, no, you don't have to have any status. You can be an H-1B living outside of the country and get selected in the lottery and then come to the country. So you don't have to be in any particular status prior to filing an H-1.
Okay, okay. So, Meenal, I hope you've got the answer for your question. And now let's take up our next question. John, I would like to know from you, what implications do court decisions have on the implementation of these immigration policies? If you can please talk about this.
If a federal district court invalidates or remands to the agency a rule or regulation, that has a huge impact on the way that USCIS does business. And so if you look back in 2020, we had the case challenging the contracts and itineraries memo that was copying RFEs in a crazy percentage, like 60 or so percent of cases were getting an RFE. And then depending on if you're a staffing company or not, approval rates were only down to 30%. And so look, after the court told them they were doing it wrong, the RFE rate plummeted and approval went sky high. So there wasn't as much work for the agency to do because they weren't having to waste time on these silly rules. So that's what we would expect.
Okay, okay. I hear your dog also agreeing to what you're saying. All right.
Yeah.
Okay, so now let's take up our next question. So next question that I have is about, if you can please talk about, are there any recent developments or pending court cases that could impact the USCIS fee increase, H-1B regulations, or lottery changes?
So the one thing that's happening at the Supreme Court level is they're considering changing the way that they look at statutory interpretation and regulation creation. And so there's this case from the Supreme Court called Chevron. And Chevron says that if the statute is vague or ambiguous, the government can fill the gap with whatever. And the courts have previously said, okay, when the agency creates a regulation, that gets deference, and they've really got to have screwed up in order to invalidate the regulation. What people think is going to happen based on the composition of the Supreme Court is that rule is going to go out, and it'll give individual judges a lot more power and authority to implement orders that prohibit the agency from doing things, because they won't have that extra layer of protection.
Okay. Okay, but let's talk about the outcomes of these court cases then. How might the outcomes of these cases shape the future of immigration policies?
So if the fee rule gets enjoined, then it'll get remanded to the agency and they'll have to reconsider, and they'll have to address whatever it is in the court's order that was the problem. So with the rulemaking, the H-1B regulation, so that's really going to hinge on statutory interpretation, whether or not the agency's bona fide job offer rule contradicts the statute's non-productive status requirement. And so that's where those fights are going to be.
Okay. They say laughter is the best medicine, but when it comes to understanding the H-1B regulations, a good joke might just be the cure for confusion, I would say. All right. So now just let's take up our next question. Or shall we take the viewer question? What would you suggest? Should I take up my question or the viewer question? Whatever you say.
Up to you.
Okay. All right. So I would like to take one viewer question, so that people should know that we are not ignoring them, and we still we have received their questions, and we are definitely going to take them. So next question that we have is from Harsha. And Harsha says, I have heard that a second round of the H-1B lottery for the year 2024 is possible. Is that true? If yes, okay, one second. If yes, when can it happen, and any reliable sources of information?
Yeah, I don't think it's going to happen. There's a month or so before they run the next lottery. I doubt there will be a second lottery for 2024. It just doesn't seem like it's going to happen based on what we've seen.
Okay. So I think people are really going to be sad and a little worried after hearing this. But anyways, I think that, let's take up our next question. Harsha, thank you for posting your question. I hope you have got the answer. Next question is from a LinkedIn user. We don't have the name, but the user says, may I transfer H-1B to new employer before October 1st? What do you suggest?
So I practice litigation, just as a caveat, disclaimer up front. I work in the Administrative Procedure Act and immigration law. I don't really file petitions. I don't file, applications with the government typically. So you're probably better off talking with your real immigration attorney, not a litigation attorney, about these things.
Yeah.
But my understanding is that you can transfer employers, but I would say talk to your immigration attorney about that just to be sure.
Okay. So, all right. So, LinkedIn user, as John suggested, you should talk to an immigration attorney, because here, right now, even though I think he might have an answer for you, but right now, I don't think he would like to give it out. But you should directly contact your immigration attorney right now. All right. So I think now I would like to come again to my questions, because I am also really interested in knowing about, the question that I have for you, answers for these questions. So in light of, USCIS fee increases, have there been any changes in the strategies employed by immigration attorneys to assess their clients?
So it's been pretty easy for immigration attorneys the last few years, that are for H-1B attorneys anyway. The rules were simple, they made sense, and they were streamlined after the government lost in court. Everything that they lost in court, they're trying to redo with different branding in the new regulation. And so that's going to require them to spend a lot more time on each individual case to make sure they can get it approved.
Yeah.
So I think that's the major shift we're going to see is attorneys are going to have to work harder on each individual case, and probably the cost will go up as a result.
So is it going to be a good year for the attorneys, at least, if not the immigrants?
Probably. Like I said, I don't file petitions, so I can't really speak to that. But I imagine they'll probably be hiring.
Okay. So, all right. Thank you so much for answering the question. Now, I would like to take up my next question, and I would like to know from you, what legal challenges or opportunities do immigration attorneys foresee in the current immigration landscape?
Sorry, say that again.
Okay. So the question is, what legal challenges or opportunities do immigration attorneys foresee in current immigration landscape?
So I think the main one that we're looking at is obviously the regulations that have come out in the fee rule. So the fee rule really comes down to, did the government provide evidence to support the rule when they did the proposed rule, and are they exceeding their statutory authority by creating the new asylum fee? And so that's where we'll be fighting on the fee rule. The H-1B reg, it's when it comes through, and I don't imagine it'll change a whole lot from the proposed reg, it is going to be a real hassle for employers and employees as well.
All right.
But the strategies there that we'd be fighting are, does the regulation contradict the statute? And in some cases, I'm pretty certain the courts are going to say, yes, it does.
Okay. All right. Okay. So let's talk about an example then. If you can please give an example or provide an example of successful strategies used to overcome USCIS fee obstacles.
USCIS fee obstacles?
Yeah.
Again, I don't file petitions, so I wouldn't be the guy to ask about fees. I have to look up the fees anytime I talk about them, so I don't know what they are off the top of my head because I don't file.
Okay, all right. No problem. Then I'll move ahead to my next question because I have too many here pending questions for you. Okay, so the next question that I have for you is about the evolving immigration policies. So if you can please give us an advice about if you can offer advice to potential H-1B visa applicants and their employers. Do you have some advice for them?
So the main thing that I would say is be incredibly cautious at the ports of entry and the consulates. So the number of fraud findings that the agency has been issuing has dramatically increased. And a fraud finding is an immigration death sentence. If they make a fraud finding against you, you're done. So the only time that really technically you could commit a statement that's false or misleading is the consulate when you're going through your visa, the port of entry, and then an FDNS site visit. Yeah, the FDNS site visit is optional. You don't have to participate. You can get out of that. But the other two are necessary stops. So just make sure that you're direct, candid, and honest with them when they ask questions. And at the port of entry, if you get put into secondary, just tell them that you want to record the conversation to make sure it's accurate. If they don't have a problem with that, then good. If they have a problem with that, I would stop talking.
Okay. Okay. All right. So, even though the lawyers and, attorneys, they tell their clients about these are the specific documentation you need to take care of, but even then they forget. So right now, I again would like to, take up this question. Are there any specific documentation or compliance requirements that applicants should be aware of?
So I think with the specialty occupation changes, we're going to see probably a huge increase in the number of applications that have an expert analysis, discussing the specialty occupation of the job. I think that's, if you're an evaluation credential, company, it's going to be good for you. But it's going to cost more and more money for employees and for employers.
Okay. All right. Thank you so much for answering the questions, John. Now, I would again like to move to my lovely viewers because they are patiently waiting so that we can take up their question and you can answer their questions. So the next question that I would like to take is from this lucky user named, okay, can we have the question here on screen, please? Majid Abdul. So Majid wants to know, so the registration fee remains same as $10, only the filing fee has been increased? Or you have
No, the registration fee has gone up to $215.
Oh my
And
God.
so, yeah, but if you're only, if an employer is only paying it once, that's great. What I expect to see is a huge decrease in the agency's revenue from that fee because there's really no incentive to try and game the system at that point.
But then, how do they justify this much percentage of increase from 10 to 200 something? How do they justify this much increase?
So
Or they don't?
It'll be interesting to see how they do it. So the statute says that you're allowed to raise fees to cover the cost of adjudication. And so, are they doing that? Are they going in excess of that? Yeah, that's going to be the issue. What they might look at is, some of these applications and fees dramatically went up, like, the registration fee is up to 2,000%. The argument could be, the registration doesn't cost that much, so you need to lower that down. Their argument in response will probably be, when it says recoup the cost of adjudication, it means everything. So we have to split up the costs among the different components. So that'll probably not be the greatest argument for us.
Okay. All right. Thank you for answering the question. Majid, I hope you have got the answer for your question, and thank you for posting your question on LinkedIn. Now let's take up another viewer question. The next question that we have is from the viewer named, okay, the LinkedIn, okay, it's covering the whole screen. So this viewer says, my H-1B petition is approved in 2022 when I was in India, but I was never stamped or worked. Currently, I am on H-4 to USA in 2023 October. Can we still use this H-1B petition approval for transferring to a new employer from USA? What if I appear in... Okay, do we have a follow-up to this? Okay, the question is actually cut off. Okay, I think I'll have to... Okay, here it is. Let me read it out to you once again. My H-1B petition is approved in 2022 when I was in India, but it was never stamped or worked. Currently, I am on H-4 to USA in 2023 October. Can we still use this H-1B petition approval for transferring to a new employer from USA? What if I appear in March 2024 lottery, and what will happen to my old H-1B approved petition?
So again, the caveat being, I don't file petitions. So if you want to talk with your petition attorney, that'd be the one to talk to. But my understanding is, yes, you can change status once you get into the country into another non-immigrant status. And the prerequisite to changing status to an H-1B is that you have an approved petition. So there shouldn't be a problem with that. That's probably a good strategy for them to follow.
Okay. All right. So LinkedIn user, I hope you've got the answer for your question, at least from John. But if you need more details or more elaboration on your question, so you will have to contact your immigration attorney. But thank you for posting your question, though. All right. And now next, let's take up another viewer question. The next question that we have is from this viewer called Bhaskar. Yeah, Bhaskar Goli. He says, if we apply H-1B from multiple employers and my lottery got selected, can I file petition from any employer from multiple employers we feel good?
Yeah, under the new rule, that's totally acceptable. So, whether or not you'll have a whole bunch of job offers from employers is the question. Employers may not want to spend that fee for a whole bunch of speculative folks that may or may not work for them. So I think the overall number of registrations is going to drop pretty dramatically.
Okay. All right. So thank you so much for posting your question, Bhaskar. I hope you have got the answer for your question. And now, John, coming back to our questions. So the question, when you talked about this significant change in the fee increase, change in the fee increase. So I was thinking about, the political aspect of it and what's the take of government or, the political factors in it. So if you can please let me know, considering the current political climate, do you anticipate further changes to immigration regulations, and how should stakeholders prepare?
So the current political environment, there's two different pieces to that. There's the career bureaucrats that work at the agency, and they're pretty immune to political pressures from from headquarters, from the White House. Okay. They're definitely immune from Congress, because Congress controls the agencies by writing the checks, by appropriating money for that agency to function. USCIS gets its funding through receipts. So Congress' impact on them is pretty minor. But the career employees, that are at the top, they basically become a hive mind, and where they all think the same way, and they're still pursuing the same strategies over years and years and years. And so they don't really change their direction. That's why we're seeing the new H-1B regulation come out, because it's implementing the rules that they wish they could follow, but were told not to before. So in terms of the White House, I will say from what I've experienced, they are not friendly to the H-1B at all. And I don't think that's going to change depending on which, party is in the office.
Mm.
The Democrats and the Republicans both don't like H-1Bs for different reasons.
Mhm.
Both are kind of without factual basis, but that's where the White House is at.
Okay. Okay. All right. But we actually had an attorney, I think on Monday or Tuesday, on our show, and I had this question. I asked this question to her as well. So I would like to know from you also that the elections are coming soon, and in the US. So can we expect any drastic changes? I mean, this is a drastic change right now that has happened, but can we expect more with the new government coming in?
So if you look at Congress, they haven't done anything in about 20 years. So they would actually have to agree with both parties to get an immigration bill through, which is going to be tough.
Yeah.
It'll be very difficult. I know that there's some lobbying efforts to get the Hire Act, put on the books, and that would, alleviate the per country cap limit and a bunch of things like that. But I just don't know if Congress has it in them to agree with each other about anything.
Okay. Okay. But what political factors may influence future immigration policy changes? If you can please talk about this.
I think economic downturns would impact. Obviously, the stronger the economy is, everybody recognizes we need more workers. So that would be the first one, and then nothing really jumps to mind beyond that.
Mm-hmm. Okay. All right. So let's take our next question then. So the next question that I have for you is about how can individuals and businesses proactively prepare for potential immigration policy shifts? If you can talk about this.
Unfortunately, there's not much you can do ahead of time because we don't always know what the rules are going to be. And even when they publish a proposed rule, oftentimes it'll change before it's finalized. So you really have to wait for a final rule to come out to decide how to react and how to deal with that. The regulatory process requires the government to publish a notice of proposed rulemaking, accept comments, and then come out with the final rule after that. And so the regulatory process is something that we can use or failures in the regulatory process are something we can use to attack in court. But in terms of planning strategy for individuals, there's not much we can say at this point.
Okay. Okay. All right. Thank you for answering the question, John. I still have to take a viewer question. We are 1 hour into the show, but if you allow me, I would like to take one viewer question, and I still have a concluding question for you. So if you can please extend the show for a minute or two, will that be okay for you?
Yeah, sure.
All right. So let's take a viewer question then. And the next question that we have is from Mark Pereira. And Mark wants to know what happens after 6 years of H-1B. Okay.
If you don't have an I-140, you have to go back into the lottery if you want to stay on an H-1B. If you have an I-140 that's approved, then you can extend.
Okay. All right. So, Mark, I hope you've got the answer for your question. Now, let's take this concluding question. So, John, if you can please talk about, in conclusion, what are the key takeaways for our viewers regarding the USCIS fee increase, H-1B regulations, and immigration enforcement efforts?
So, with the fee increase, obviously costs are going to go up quite a bit. And it's going to go up for people filing the I-129 and I-140s. That's pretty much all of the fee changes are targeted at that category. So, you expect some resistance from employers wanting to pay those fees, and they just get too expensive for them, and they'll offshore the jobs.
Okay. Mhm. All right. And also, I have this viewer question here that I would like to take. The viewer is Jitendra, and Jitendra wants to know: is it possible to transfer from H4 to H-1B visa without obtaining an H4 EAD?
Yeah, the EAD is not if you're changing status from H and you've been selected in the lottery already,
Mhm.
I mean, that's the main thing. You have to be selected in the lottery. But if you're changing from H4 to H1, there's really no requirement to be on an EAD.
Okay. All right. Thank you, Jiten, for your question. Now, next, I have this question from Venkat. And Venkat Satya Praveen. Okay, the name is too long, so I would not like to waste the time taking the name. So, Venkat, let's call him Venkat. Venkat says, for year 2024, will market come back in terms of opportunities, or we have to wait for some more time?
Yeah, I don't know. I'm not an economist, so I can't really answer that. If I could answer that, I'd be retiring and doing investment banking. So
Okay. All right. So, Venkat, thank you so much for posting your question. Now, I'm not sure why people are giving out their WhatsApp numbers, because I have these viewers here. They are giving, John, I'm really not sure. They are women who are giving actually their WhatsApp numbers. I'm not sure if they're for you or what. But yeah, but now let's take Kamal's question. Kamal has posted this on YouTube, and Kamal says, I would like to know how much does it cost to change the visa from H4 to student visa? How long will it take, and what are the requirements?
So how long it'll take is the real issue there. That's the unknowable. It should only take a couple of months. I think processing times for that are down around 2 or 3 months at this point.
Mm-hmm.
But the USCIS sometimes will take ridiculously long amount of time to do anything.
Yeah.
So in terms of the cost, you have to file the I-539, and I don't know off the top of my head what the new fee is going to be for that,
Mm-hmm.
but that's the document you got to file to change status.
Okay. Okay. Thank you, Kamal, for posting your question. I hope you've got the answer for it. And now, last but not the least, I have one more question. Julie Violet. And Julie says, Julie has posted this on YouTube, and Julie says, my H-1B application was filed after being selected in the lottery. However, I got laid off before its approval. Can I proceed with a new employer, or do I need to re-enter the lottery next year? What do you have to say?
Talk to your immigration attorney about that one. That's I think you can, but again, I don't file petitions. Happy to, if people contact me, happy to give them referral for good attorneys in their area.
Mm-hmm.
But yeah, I would talk with the experts on that.
All right. Thank you so much. Thank you so much. Firstly, Julie, thank you so much for posting your question. And then thank you so much for answering it so beautifully, John. And thank you so much for answering all of our questions so beautifully. I'm sure, it's just Wednesday and you must be really busy, with your work. And I know that you're working from home at the moment. But thank you for taking our time and coming and doing the show. It means a lot to us. And everyone, I would like to say that if you need any help, don't forget to reach out to John at 703 216 8148. His email is john@waston.law, and his website is waston.law. As simple as that. And so, John, thank you so much again for coming to the show, doing the show, and answering all of our questions in so much detail, in so much depth, and informing our audiences about all these fee changes and H-1B regulations and lottery. Thank you.
Thank you.
All right. So, everyone, I would like to say that if you are looking for project placement or visa sponsorship, reach out to me on my email, rajni@highrightypeople.com. And my contact number is +1 732 707 9151. You could also visit our website, which is www.highrightypeople.com. Remember, we also sponsor work green cards and H-1B visas. Well, that's a wrap for today's show. And Remember, folks, understanding immigration policies might be as complex as rocket science, but with a dash of humor and lot of perseverance, we can navigate through it all. Stay tuned for more exciting discussions and expert insights on Immigration and Jobs Talk Show. Until we meet again, don't forget to subscribe to us. Thank you for tuning in. I'll see you next week. Bye for now.